Mainly during the 90s, before the EU enlargement, several member states, Austria, Italy, Netherlands and Sweden in particular, from the west of the European Union, concluded bilateral investment treaties with Eastern and Central European countries, which were then not already member of the EU. Approximately 180 agreements have been concluded, compared with more than 1,000 BAT agreements concluded by European states with third countries. Those agreements provide both substantial rights to investors and procedural rights to them, such as substantial right, the national treatment, fair and equitable treatment, minimum standard of treatment, and the right to receive due compensations in case of expropriation. In line with modern investment law, those treaties also contain, as I said, procedural rights. Each contracting party consents to submit a dispute to an arbitral tribunal. The arbitral tribunal is often constituted for each individual case in the following way. Each party to the dispute appoints one member of the tribunal, and the two members thus appointed shall select a national of a third state as chairman of the tribunal. The arbitral award is binding for the defending state. It can provide a right to compensation for the investor who brought the complaint. The rationale behind those treaties, the ratio legis, if you want, is to provide an attractive legal environment for the EU investors. The host state indeed accepts the possibility for those investors not to submit the dispute to a national judge, but to benefit from a discriminatory legal treatment through those conventional and procedural rights. The international procedure is supposed to be more efficient and more business-friendly than the common one, the national one. Those agreements concluded between Western and Central and Eastern European countries remained into force after the EU enlargement and therefore became intra-EU BITs. On several occasions, national but also EU investors brought complaints against EU member states and triggered the first clashes between international investment law and EU law. I can briefly mention a case such as the Mikulae case. In this case, the matter was referred by Swedish investors, Mikulae and others, under the BIT concluded between Sweden and Romania. The claims arose out of the government's introduction, the Romanian government introduction of a series of investment incentives for the development of certain disfavored regions of Romania, and from the subsequent partial withdrawal or amendment of those incentives in the context of Romania's accession to the European Union. The final award rendered by the arbitral tribunal condemned Romania to pay damages to the claimant, more than 180 million euros damages. During the procedure, the European Commission submitted an amicus curiae brief to support Romania's arguments that withdrawing the incentives was required indeed by EU law, and contending that if the tribunal were to award damages to the claimants, such an award would constitute illegal state aid under the Treaty on the Functioning of the European Union, more precisely Article 107 of the treaty. This position was confirmed by the Commission decision published in 2014, which is now under the review of the EU General Court. The European Commission also asked all its members to terminate those agreements, considering that they were blatantly in breach with basic principles of EU law. It even started in 2015 infringement proceedings against several EU member states, which led Italy and Ireland to denunciate the intra-EU BATs.